Okay, without waiting much, let's start the session. Welcome again to all of you. Happy afternoon to all the participants. We cordially welcome all of you to our yet another webinar from Anveshan Stubble. Today, we will be covering certain key aspects pertaining to estate planning. However, before we jump into the session and the topics, we would want to briefly introduce about us and the presenters today. About us, so Anveshan is a boutique consulting company, consulting arm of experienced CA firm Suresh and Co. We provide holistic financial and regulatory solutions for all the needs, business needs, and we believe in working for the solutions, and we strive for solutions from us or through us. The areas of our expertise, we provide advisory and consulting on corporate structuring and restructuring, tax and regulatory strategies, fundraise and M&A transaction support services, due diligence services, valuation services, startup entities support, business succession and estate plannings, long-term compensation plans, setting up of those plans, virtual CFO services, and arbitration support services. These are the areas where we, hold our expertise and provide our solutions. Today, our speakers, Mr. D.S. Vivek, Managing Partner of Suresh & Co. He is a seasoned tax professional and beyond that, in fact, with nearly 27 years of experience in planning tax domestic and international taxation, business structuring, regulatory compliances, and investment strategy. He has advised numerous families and businesses on various aspects. And he's a result-oriented person, as I know and seen him. Myself, Arun, I'm partner consulting at Anveshan, having 29 years of experience on various aspects. Again, we work together on various aspects. I have my colleague Maithili. She is a chartered accountant again, having more than 15 years of experience, and she holds experience in valuations, due diligences, transaction support services. She brings strong focus on estate planning, helping families and business entities to streamline their wealth, etc. And she believes in thinking before starting anything. Yeah. So, just a minute. Yeah. Today we have our guest speaker, who is an advocate by profession. I'll welcome Mr. Santosh Murthy, our Vashishta. He's a senior legal professional. He also practices corporate legal affairs and also advises on risk advisory and management. He is having 26 years of experience in these aspects, litigation and advising on corporate law matters. He has expertise in corporate law, legal affairs, including contracts, drafting of contracts, identifying risks as part of risk management, and strategic advisory for business across sectors. He holds expertise in estate and succession planning, which includes wills, trusts, family settlements, and guiding clients on regulatory and legal implications. He is also trusted advisor to various families and families running family businesses, where he offers strategic counseling to protect their assets, ensure smooth succession, as well as mitigate future disputes. A warm welcome, Mr. Santosh Murthy, sir.
Thank you very much, Mr. Arun. Thank you, Vivek and Maithili. Thank you very much.
Thank you. Yeah, I would hand over the mic to Mr. Vivek. We want him to speak about importance and key aspects and why estate planning.
Oh, happy afternoon to all of you. Thanks for joining this webinar. The objective of this webinar was to create awareness amongst all of us on why estate planning is of importance to you. When I've been talking to very, very senior people, businessmen, entrepreneurs, high net worth individuals, and common public, it is something that we have seen that this aspect has been very much ignored. Is it because of lack of awareness, or it's just negligence, or just the fear of doing something called an estate planning? Is that what it is? So based on that, we said that we should create this webinar to create awareness as such. And when I talk about importance of estate planning, rather than telling it by why it's important, let me think about narrating few incidents that have happened in my life when we have interacted with various people as a client or as a friend, etc. That itself, I think, will let us know what is the importance of estate planning. See, the basics of estate planning is that there's a will, GPAs, trust, nominations, etc. Right? And one, if you don't do estate planning, the law comes in, which they would be explaining over the thing, and the law will act upon it and then distribute the assets as it is. I was helping one lady buy a property in Malleshwaram, very, very prime property, worth more than 25 crores, was being bought from a family. In that family, the people who were selling it were one lady and her two daughters were the owners, and they were selling this property. When we started doing the diligence, we looked at it, we came to know that the lady's husband had actually bought this property and he died at a very young age. And based on that, the three of them decided equally they will share it, and then they had made the kata in their names, and then they have been living on. And when we started looking at from a buyer side, we looked at it. We asked this person whether this person, the husband who actually acquired it, had he got a will. They said no, he didn't have a will, and he passed away very early. So in fact, what happens when he does that, his property actually goes to his mother, his wife, and two children. So that is what happens. So actually it is not 1/3, but it is 1/4 to each one of them is what happens it. Unfortunately, in this case, the mother who had inherited 1/4 from her son, she also passed away, and she had actually 4 children, including the son who passed away. That means to say the 1/4 of that building actually again had to go in 4 splits as such. So when we as a buyer, when we are advising it, we said that it's not sufficient that only 3 people's signature is sufficient. We need the signatures of the other family members who had inherited from the mother. This became pretty complex. People were not even aware as to why it was required, etc. So these things can happen when there's no proper will, becomes complex. And then, in fact, in this case, the buyer bought a property at a deep discount because everybody was not traceable, and then it did not happen. So that is the reason why a will is required. Estate planning is not just about creating a will or anything. It's also about how you arrange your affairs. One incident which I came across today morning when I was talking to one of my friends, what they were talking about, it seemed there was a chartered accountant who died during the COVID. He had good money in his bank account, had good properties, etc. But even for the 13-day rituals, the family had to borrow money as such. Why did it so happen? One, because he had not nominated anybody to access his bank accounts. He had not shared his credentials. At least the internet banking account, he could have shared it with them. He had not done that. And then there was no funds parked in various other people's family members' account, and nothing was done. And the cash at home was very, very small. So even all this is part of estate planning. It's not just will, trust, etc. But how do you manage your affairs? That's also part of it. So therefore, you have to look at nominations, you look at having funds dispersed across it. These are the things that would be required. And in another one incident, there was an aged person having a property, and there was a medical emergency, and they had to liquidate this property and then use those funds for medical emergency in the family. Unfortunately, this person, aged person, had suffering from Alzheimer, and he'd had a memory loss. So in this case, he's alive, but he doesn't have a memory, and therefore he is incapable of doing the transaction of selling the property. Property is, buyer is there, seller is there, but he's not able to do it. What they should have done, they could have done a GPA. He could have done a GPA when he was in sound mind. You could have given a GPA in favor of his family member, and his family member could have done that. So they had missed out on that, and again there was this issue about it. Of course, you also see that there is the recent case where Sanjay Kapoor's case, we all aware about it, what's happening in the news. There is a will, there is a trust, everything is done, but they're still fighting about it. So it's not just that you have a proper estate planning, you don't fight it. Even after doing all the estate planning, the fights were done. Why is the fight done? basically one understanding what we hear from the media is the father gave the shares to his mother or to his wife and told in a family conversation after his mother it will be split into three children. But in the will, he had done it had all gone to his mother. Once his mother has got it, for her, she gifted it to her son Sanjay Kapoor. And then Sanjay Kapoor in turn did a trust everything he had done. So here, by just doing a will, they thought it would be solved. But instead of that, if they had thought about a private trust where the father, instead of giving it a will, had put it the mother as a first beneficiary and secondary beneficiaries are three children, then the dispute might not have seen this kind of a bloodbath what's happening in the industry. So these are the challenges which happens day in, day out that happens as such. And one, to have a peace of mind, I think it's very important that all of us get into the estate planning. That is how wealth can devolve into your family, provide some kind of a peace to the family. That is actually a very emotional issue that one would be going through. A lot of trauma would be going. Along with that, if there are a lot of financial challenges, legal issues that happens, that be pretty challenging on that. So I think that is why each one of us needs to work upon estate planning. And it's not a taboo subject. I've been a speaker in the global conference on estate planning. Everywhere the people are afraid about getting into estate planning. It's not a taboo subject. I say it should not be as such. One should get involved in it, understand it, and get into it. So this webinar is going to create that awareness for it as to what are the details of estate planning and then how you should adopt it. So and make this interactive, the entire webinar, make it interacting. There is this chat window where you can keep asking questions, and it depends upon the speaker when he wants to answer the question at that time, or there's a Q&A time that will be there. The speaker can answer that. Thank you. Over to you, Arun.
Thanks, Vivek. Very beautifully articulated about the importance of the estate planning with the live examples that you have given. So I think most of us agree that why estate planning and uh, it is not necessary just enough to have the document in place, but it has to be structured well. So thanks for that. So participants, the focus areas for today, will jump into these focus areas. Before we get in, I just want to announce we are recording this webinar and also will be putting up it in Anveshan YouTube channel. And the presentation also will be put up, uploaded onto our website. The links will be shared via email for all your references. So please make best utilization of this webinar also subsequently. And you can always reach out to us for anything. So getting on to the session topics, we'll be discussing about importance of will, practical challenges in will, understanding succession laws, um, your first step towards the will, and overview of private trust, importance of private trusts, and approach to registration. And then, of course, my favorite session, that is Q&A session. Lot of new things we get to learn during the Q&A session. So we'll jump on to the first of the focus areas. So before that, what are the commonly used methods that we have come across? Um, that is will. We have heard about will. We have heard about private trusts. Of course, we have heard about other forms also like settlement deeds and release deeds. There is a poll that my colleagues have put up. Request you to participate in the poll also. We will have 4 polls and a feedback poll also in towards the end. Your feedback is very important for us to improve ourselves and do a better presentation in the future. So coming back to the subject, commonly used methods, wills and private trusts or release deeds, settlement deeds, these are the commonly used methodologies for development of assets or transfer of assets that we have come across. So let's talk about the will. So will, we understand a person writes a will and then he addresses all the assets that he has acquired or he owns or he holds the ownership. But here, many a times we observe that will addresses just the personal assets. but at the same time, there are business assets also. So when I say business assets, there are businesses which are operated, managed, and owned by the family or the family members. They also many a times become part of the asset pool, family asset pool, and hence the will should also address the business assets. However, today we are not covering the business side of the succession. We are addressing only the individual assets or the personal assets, and because this itself is a very vast topic, and we would be announcing the business assets or the business succession part of webinar soon. We'll be announcing the dates for that also. So let's jump into the importance of will. Of course, like Mr. Vivek mentioned some time back, will is very important. All of us should have a will in place, but we come across at least 90% of them do not have a will in place today as we speak. Um, even you can check within your circle, within your family circle or clientele or your peers at your office. Many of us do not have a will in place. Even I was surprised when I got to know that Mr. Dhirubhai Ambani himself did not have a will in place. He passed away in 2002. That is when all his business empire, was supposed to be managed by his two sons, Mukesh and Anil. That is where the rift started between them. And then, because there was no succession plan, especially covering the businesses also, apart from the personal assets, it became difficult for both the sons to, that is brothers to, manage the affairs. That is when mother stepped in. She did the broking between the children, and the settlement was achieved. That is where Mukesh Ambani took over core businesses, while Anil Ambani took over the new age businesses. So mother came in handy and she stepped in. I think she was a powerful lady, so she could solve the problem. But many a times that is not so. So hence, will is very important for everyone who holds some assets or large assets. The value of the assets are not necessary, but it is important that will is drawn to have the peace and harmony within the family. So that is where why it is needed. So to create clarity for loved ones, that is family members, regarding the assets owned, bring in visibility for asset pool and identify the beneficiary or subsequent owner, that is post development. And also many a times, as Vivek mentioned, during the bereavement, the family is already in grief. At the same time, they need to complete their rituals and processes. That also requires money. So hence, uh, please ensure that the family gets to enjoy the money and the assets at right time, right point in time, and not allow them to struggle to gain control over them. So at the same time, will brings avoids ambiguity and avoids family disputes with respect to distribution of the assets. And it also allows flexibility to attach conditions. So will need not be unconditional. It can be conditional. And many a times we have seen the court judgments where they say the father or the mother should have put in conditions saying that the children should take care of them, should ensure their lifestyle is taken care, the living expenses, medical costs are taken care of, and that is when they get to gain control over the assets. So here I would want to call upon our guest speaker, and want him to throw some light on how these conditions to the will can be attached, how does it play, and how does the courts look at it. Sir, if you can.
Yeah, thank you, Vivek and Arun. It's very well explained by Vivek and Arun itself. The right example today morning only, actually, I had to visit emergency of one of the death in one of the our friends actually. How it works out is if there is no estate planning, it so happened that husband, wife, and four children. The eldest son stays in London for past 30 years and is now the US citizen, directly a UK citizen. And now the problem is the property owned by the father was along with the youngest son in the family. It so happened that the other three members have not released the deed, the loans, everything is taken by the youngest son. The issue and the topic near the dead body was how to get these things resolved and how to solve the issue that the youngest son gets all the benefits so that tomorrow there will be no issue. The mother was more worried because the youngest son only took care of both the parents. And this is where, as Vivek and Arun rightly suggested, there's no proper estate planning. And if something really goes wrong over there, at the last moment, everyone has to run pillar to post to get resolved. Thankfully, there was no such issue over there. We had to resolve it in an amicable way, but they were very educated and understanding people, so they understood the nuances. What we suggest generally to all the public is will doesn't have any age criteria. All the people above 18 years as such who are major in age, the Constitution of India suggests that you can have a registered will if you have properties in your name. It's better that, and there is no mandate that it should be registered also. It can be unregistered will also. So it's better that you delegate and do if you have lots of properties and you feel that there should no dispute in the family. Touch wood. If there is no dispute also, if there is dispute also, it's better to create a sort of will, which will further not create any ambiguity between the future generation for that matter. For that matter, if there is a widow sister staying along with you, or if an unmarried daughter also staying with you, so what are their rights and privileges over the property? It should be better that you should know everything in that case. Like for that matter, if you have lots of savings accounts, demat account, any financial accounts, how the plannings are done over there. It doesn't matter that only creating a nomination doesn't mean that that the property or the finances directly go to the nominee. The Supreme Court recently has given a judgment on that also, that nomination itself will not supersede the will. If the will has mentioned that the nomination is that, but it is like a custodian. The person having a nominee is just a custodian. And if the person creating a will suggests that this so-and-so finance of the bank account should go to second child, the third child, the will supersede all the other nominations also. So
Yes, sir.
I would suggest that everyone has to create a will, because in today's generation, most of these cases we came up in a very rampant stage during the COVID time. And generally, we off lately have come across a lot of issues also, because most of us heart attacks are there, and there is no age group of heart attacks for any sort of human being in India. And so that's what celebrities or the normal people also, they have become more concerned that how to create a will and how to get registered. So at present, I'll keep a stop over here and continue with Arun's further steps. Actually, we'll discuss it
Thank you,
further.
sir,
Yeah.
for your thank you
Yeah.
for your insights. And I think some of the aspects that you mentioned about nomination, etc., will be covering in our subsequent slides.
Correct.
I'll still call upon at that point in time for your broader
Sure.
and deeper views, sir. Thank you. So moving on, yeah, understanding the property and what can be willed, because this is one aspect where even I get confused many times. At least I understand self-owned assets, but when I think about ancestral property and inherited property, generally we think it is synonymous or overlaps, or it is one and the same, but it is not actually. Self-owned assets, it is very clear. We during our lifetime earn, and out of the earnings we acquire assets, or it is acquired through gifts. And in case of self-owned assets, we get to decide to whom to transfer it to, or to whom to bequeath. So that is very clear in case of self-owned assets. So let's understand what is ancestral and what is inherited property. So in case of, I'll touch upon first inherited, and then I'll come to the ancestral. In case of inherited property, it is acquired through a will or gift or succession from a relative on their death by way of partition or release. This is the legal language provided with respect to inherited property. So, what does it mean? I should have received it from somebody on their post their death through their will, or they should have gifted it to me, or through succession, I should have received it from one of my relatives. Again, succession there are different succession laws. As per that, I should have received post their lifetime, or it can be by way of partition or release deed also. And here again, since it is inherited property, I become the absolute owner of that property and I can will it or transfer it as per my will. There is no restriction per se. In case of ancestral property, the law is slightly different. It says any asset that passes through 4 generations. In case of a Hindu family, then without division of the property, it passes through 4 generations. It gets called as ancestral property. And in that situation, post 4 generations, it requires consent of all the co-parceners. When I say co-parceners, here I'm bringing a word which is relating to HUF. When it can be a HUF, or it can be a joint family, or it can be a pool of assets owned jointly by the family. So, if the post fourth generation, that is fifth generation person, if he or she wants to will it or transfer it to anybody, all other members also should give consent, without which the transfer of ownership is not effective and complete. So to understand this little bit more, we have plotted an example here. If you observe on the left-hand side, it is inherited property, wherein father, out of his own earnings or through a will or settlement or gift, he would have received that property and he's willing it to daughter. This is absolutely allowed, and this is not treated as ancestral property. On the right hand side, if you observe, there is father and then son, and property moves from father to son and son to his son, and then great grandson, that is D. So if you observe, the property has moved through 4 generations. This is where the assets gets called or categorized as ancestral properties. Sir, Mr. Santosh Murthy, I'll call upon you here just to provide some legal insights on this aspect, sir. How, for example, if there is an ancestral property as part of will, how does the succession law play out? That is first question that we had. And how do we ensure that these ancestral properties are transferred to outside the lineage in order, and how to ensure that it is legally right?
See, basically, an ancestral property, as rightly suggested by Arun, it should 4 generation will come son to son, then grandson, then great grandson. That is true, as suggested over here. And again, it will not go unless until it has been transferred within the family, like son and grandson, through proper documentation, registration, well and good. And there is concept here also, settlement deed and release deed concepts are here. It may so happen sometimes like one or the other son may also not require the property. So in that case, settlement deed will not come into picture. It will be release date. For example, if a father has 2 sons, son A and son B, the A wants to release the property here, A will directly give a release deed to the son. There will be no settlement over here. But in that event, release deed is a concept wherein we relinquishes the entire right of the property. Settlement deed is a concept wherein he is just settling within the family so that no further disputes are there. There is no right as such which is he relinquished it. Further, his own children can come and take a right over it. So there are concepts in Supreme Court ruling which are to some extent, if not clearly mentioned in any sort of a deed, it can be relinquished deed or the release deed or settlement deed. If the clear terms and conditions have not been called up, the dispute starts there. So better to mention everything crystal clear, and the terms and conditions within the family should be very crystal clear, which is brought down in any sort of a deed. Hope that makes a clear
Yes,
understanding.
sir. Yeah. Thanks for that, sir. Participants, we have one poll going up now. Request you all to participate. In the meantime, we'll move further. So, as Vivek was mentioning earlier, and also Mr. Santosh Murthy, um, we keep hearing about nomination. So, is nomination akin to a will? Is it a pseudo will, or will it give ownership rights to the nominee? Let's dwell a little bit more here and understand how it works. So here, what we observe, understand is a nominee is a person appointed to receive the benefits or assets. When I say receive, he only receives and he cannot enjoy the benefits. He only receives the benefits. So what does that mean? So a nominee is acting as a custodian or a trustee of those assets, and he's not a legal owner. And a nomination doesn't define or give way for legal heir having ultimate rights. So it is just a person nominated to manage the assets, and nominee generally cannot retain assets. So then why is it even insisted? We come across banks, insurance companies, we come across mutual funds, and even demat account. In case of demat accounts, people keep asking about please do the nomination, even when by the authorities, in the sense the bank authorities or bank regulators, they also recommend nomination. So why is it even important? So, as I mentioned, nominee is a person who helps in managing the assets post the lifetime of the person. Hence, it helps in faster settlement or transfer of assets or devolvement of assets, faster access to the funds, because funds are necessary at some point in time post the lifetime, and hence that access to the funds are provided. But when the funds are accessed, the nominee also should ensure that it goes to the right claimants or beneficiaries. And generally, this is where we recommend that nomination should also be in line with the beneficiaries who are stated in will, unless and until the beneficiaries are not capable of managing these assets. This helps in preventing legal conflicts and legal misinterpretations also, and also avoids delays in transfer of assets. So, as I mentioned, generally we have observed this kind of process in case of banking, in case of mutual funds, equity shares, listed or unlisted, or insurances. So, I'll call upon Mr. Santosh Murthy here to briefly talk about the 2015 amendment, sir. Um,
Yeah, thank you, Arun. Yeah. See, again, as rightly suggested, the nomination and also earlier discussed, nomination is just like a custodian of the property. It can be for demat accounts, all your financial transaction insurance, or the savings account. How it works out, unless until there is, to be very precise and legal and practical thought knowledge, what we suggest is, unless until there is no dispute further, it is well and good the nominee can take over the whatever the proceeds are there in the financial accounts. For that matter, it can be insurance money, it can be term life or the demat account, share proceeds, everything. But if a dispute arises within the siblings or the whoever the widow is left over, they can challenge it before the court if the will is not there in place. And the will, if it's clearly mentioned that, for example, uh, Sita has two kids, Ram and Lakshman. So the Lakshman is made the nominee, but Ram, there is nothing mentioned of the property. And there's no will also. So that time Ram can go directly and challenge it before the court, stating that there is no will in place, but the property, whatever has been nominated over here, I also have a 50% right over it. So it's very much valid to go before the court and get it done. But if there's no dispute, and if he feels that, okay, Lakshman can have the entire property for that matter, so it can be relinquishment deed, for example, rightly suggested, release deed can be made there and there itself. Just by, we also suggest for most of the clients that you should have a nominee in the bank accounts and the whatever the financial proceeds are there. That doesn't mean that he has 100% right to our entire property. There are certain exceptionals, keeping in mind the EPF kind of thing, provident funds and gratuity funds. Those are a bit of an exception because there again 100% or 50%, whatever the percentage is there, it can be well and clearly made understandable there itself and written over there in the records only. But apart from those other things, nomination is just a custody. If it has been challenged before the court, we have to go as per the court order. That is very crystal clear. Am I correct,
yes, sir.
Arun?
Thank you,
Suggest
sir.
over there. Yeah.
So, thank you, sir. And as per what we understand is, as per 2015 amendment, spouse, child, or a parent, they are considered as beneficial nominee whenever they are nominated for these financial assets.
Correct.
Yeah.
Unless until challenged further. If it is not
Challenged in the
challenged,
court.
well and good actually. If challenged, they can reach out the court clause.
I've understood, sir. Thank you. So we'll move forward. So, as I was referring to, with respect to succession, when there is no will, and Mr. Santosh Murthy also was mentioning, when there are no wills in place, no documents to talk about who owns what subsequently, there are laws. Hindu Succession Act covers Hindu, Buddhist, Sikh, and Jain communities. Indian Succession Act covers Christians and special marriages, that is, intercaste marriages and other religions not covered under Hindu succession, and Sharia law, which is Muslim personal law, especially particularly pertaining to Muslim community. So these are the three laws which covers how the succession should be given effect to in the absence of a will. So here we have tried to analyze how the succession law works in as per Hindu Succession Act. So if you observe, let's start with Hindu male. Let's understand Hindu male. So post lifetime of a Hindu male, the class one legal heirs get equal shares. I'll touch upon class one legal heirs little in a short while. And if there are no class one legal heirs, it shall be equally divided amongst class two legal heirs. And if there are no class one and class two, then it will be divided amongst agnates and cognates. If none of the above mentioned here exist, then it will go on to the government. So government can take over those assets. And in case of Hindu female, the law is slightly twisted. First, post her lifetime, it goes to her children and husband. And if there are no children and no husband, I mean, post lifetime of the husband, then it will go to husband's legal heirs. So it will come back to Hindu male lineage. Then post that, amongst her father and mother, if there are no husband's legal heirs, it will go to her father and mother. There again, it will go to father's legal heirs, post lifetime of the father and mother. And post lifetime of father's legal heirs, it goes to mother's legal heirs. So it is like little complicated here in case of Hindu female as compared to Hindu male succession. Why is it law is so structured? Sir, if you can explain a little bit on agnates and cognates. Um, so the slide is, I think, helpful here. If you can explain a little more on class two legal heirs also.
Yeah, basically, to that extent, I would suggest that Hindu law is more clearer than any other law for that purpose.
Okay.
It clearly states that 1 + 1 is 2. So there is no major concern. It generally comes when the dispute arises. Unless until everything is peaceful, it's fair. So class 1 legal heir is rightly suggested in the PPT over here and what as suggested by Arun also. Whenever in a family, typically nowadays it's a nuclear family. Now, it's hardly we have come across situations when a joint family property comes up. So I'll set up with an example here. We recently, 6 months back, we had received a sale of a house in Agra. So that Agra property was 1927. After 1927, there was no sale in the property itself. But that time in 1927, the entire family was a joint family of 60 people. But today, the property who was staying there was only a single nuclear family. And no one was in touch of that property because the lot of maintenance was there for the entire property. No one was supposed to ready to shell out money for that purpose. I'm rightly giving an example how it works out here, rather than going to technicality so that the general public will understand here. It so happened that when the property was about to sell, it's mandatory for such kind of issues to directly give a paper publication. The paper publication was made, the token advance was taken, everything was done. Immediately when the token advance was taken, paper publication was done, 15 people from the family reached out directly to the house, stating that we are the other legal heirs also here, and we need whatever the percentage has to be discussed and settled. Here the settlement deed comes into place, or rather release deed, more than release deed as such. They have tried to do the settlement deed here because they had to settle amongst themselves first and then further release it. It so happened that we had to knock the doors of the court, and within 1.5 2 years, we have to get an injunction order also stating that all this family members for past 25 to 30 years, no one was staying in the house. So we had to technically prove out by calling up the ration fellow, the milkman, everyone to the witness box, stating that the only 5-member family was staying in this house. So that's where everything was brought to picture, and that's where certain times, like legal has, how it works out is the same concept: mother, wife, son, and further how the generations is divided and it becomes a nuclear family. If it is clearly classified there, who within the family has come a proper lineage to the property. If there is certain discrepancy, the court has the inherent power to come up with the order to say that this property belongs to so and person and 100% right is this person to sell the property. So for example, in the same Agra case, the nuclear family won the case, but still out of love and affection, they created a settlement agreement by passing on certain amount to other relatives who had reached out to them. So I think with the example, it's made it clear rather than going more into technicalities. We can take up the questions if is there anything so that after in the Q&A sessions.
Absolutely,
Correct?
sir.
Yeah,
Absolutely.
sure. Thank you.
No, no. Always live examples are easier
Yeah.
to understand and convey the message
Correct.
than the technical aspects. Thanks.
Very
Thanks for
true.
that, sir.
Thank you.
Moving forward. So class 1 has, as we discussed, wife of the person, his mother, his elder son, younger son, his daughter, and wife of deceased, deceased son, and then daughter and son of son. So that is grandchildren. So I'll move ahead. So this is one important topic we felt we need to include here: the importance for women to have a will. Of course, in a family, when members are present, it is important everyone makes a will, and everyone creates wealth or everyone owns assets, and hence it is important that everyone creates a will. At the same time, there are some nitty-gritties around women. So it is about married woman without children, or widowed woman, or in case another category is woman separated but not yet divorced. So there are intricacies here. I'll ask Mr. Santosh Moti to dwell little more on these aspects. Sir.
Yeah. So again, in the creation of will for a married woman without children, it so happens that it first say will go, or rather the rights will go to the husband's side if the husband is alive. If not the husband, again it will go to her parents in that case. It can be if the parents are alive over there. It will not go to the in-laws parents. For example, husband is the first person. If husband parents are alive, it will not go, but it will go to the wife's side only, the lady who is doesn't have children, towards her parents, and later on to her siblings in that case. So this is for a married without children. For a widowed person, for that extent, if it's a lady again, if she has children, well and good, she has to create a will, or in all the technical process what is to be created. It's a very clear, crystal clear thing. Separated and not divorced, it's a bit of a catchy situation, because herein again, if there is any sort of a court case prevailing over there, any to that extent, whenever there's a court case prevailing to a dispute of a divorce or a family matter, if the property has been sold without the permission of the court or attention of the court has very right to stop it and get an injunction order over it. So it becomes a tricky situation over there. Unless until the dispute is resolved amongst themselves, they are technically not supposed to sell the property. If it is brought to the attention of the court can immediately get an injunction and stop over that thing.
Got it, sir. Thanks for that.
Yeah, thank you.
Yeah. We'll move forward. Yeah, key aspects to be included in a will. So we should all adhere to this basic aspects as part of the will. Details of the testator, that is the person who is writing or making the will. Details of the beneficiary, details of the executor, details of the property and their division. When I say details of the executor, post lifetime of the testator should have ideally identified one person, one or few people to act on his behalf and ensure the contents of the will are actioned. So it can be a legal professional appointed by the testator, a friend or a family member, or together a group of people. So This is very important, and details of the property and their division has to be clearly called out. And if there are any conditions to be attached, yes, it has to be attached and called out clearly. There cannot be any ambiguity in these conditions. And then witness is all the more important because witness plays a vital role whenever the will is challenged. So these are the basic requirements of the will. And sir, any other area that you feel it is important apart from this?
Yes, to just throw light, it's not mandatory that the will should be registered. Keep in mind that a unregistered will also has that 100% weightage as a registered will. But in both the cases, as rightly suggested by Arun, there should be no ambiguity. So, for example, there are 4 accounts. It should be clearly mentioned if you are giving to 4 kids, account number 1 should go to account number 2. It should be very specific and crystal clear. Mentioning the account numbers also will help a lot actually. So we had come across a will of a Parsi person in 2006 when it was so much, he had a lot of jewelry also. So each bangle, each earring, he had bequeathed the property to his 3 kids actually. So he was very crystal clear by mentioning that a red color ruby should go to this daughter, green color stone should go. So it was very specifically done. There was no ambiguity in any of the property, including his demat account and the financial saving accounts also. It should be crystal clear without any sort. When ambiguity arises, then only dispute arises. And the witnesses should be neutral person. It should not be beneficiary. Some third person that would be more helpful in that case. Like, yeah, Arun, over to Arun.
Thank you, sir. So very well explained about the clarity and clear message being conveyed in the will. Thank you for that.
Correct.
So, moving upon executor and his importance. We'll briefly touch upon an executor in a will is a person appointed, as I mentioned, by the testator to legally manage and administer the estate and ensuring that his wishes that are expressed in the will are carried out. So it can be legal representative of the deceased person. Executor can sue others for recovery of debts. He's duty bound to distribute assets. So he's acting like a trustee. He ensures probate process is undertaken, and he also incurs funeral expenses. If there are any debts incurred by the testator, he also has to settle. He has to ascertain the assets, in fact, as per the will, and do the mapping. And if there are new assets created post the will, before the demise, then he has to again ascertain those assets and ensure it is addressed as per the will. And testator need to take approval. That is, before appointing him as an executor, he should have taken approval from executor to act as an executor. So these are the importance and role that executor plays. So moving forward, as sir has mentioned, whether the will to be registered or not. So unregistered will also written subsequently, executed subsequently, also supersedes a registered will, and it need not be. The law doesn't mandate registration of the will, but if it has to be registered, it adds an added advantage because there is a record with the sub-registrar. So the process is a witness as well as the testator should go to the registrar's office and ensure the document is vetted and it is signed, executed properly, and then the registration process is taken care. So, sir also mentioned the subsequent will, which is not registered, also supersedes the registered will, prior registered will. And sir, a little bit information on how a registered will help in avoiding probate process or helping in probate process.
See, registered will directly creates entire thing which is technically or legally you can say valid to move it ahead to the court and get it properly executed by creating a probate over there. Probate is nothing else where the court directs the person who is supposed to execute. An executor of will, the court appoints as per the whatever details were shared over there, who has to execute. Is just like in a layman language, like an auditor of the entire will. The entire assets is placed before him. who will create a proper audit sheet that what is going to which son, daughter, or whoever it has been nominated over there. The entire things has to be detailed out, called out in a proper Excel sheet for that case and presented before the court. If at all there is some certain sort of ambiguity, or rather if there is sort of enhancement in the property, how it is further taken care and how it is distributed. If technically this thing is there in a register which is crystal clear, this helps a lot also, because all the technicalities are covered and has been stamped. There is no stamp duty for that matter. The registration fees is completed there. But in an event, if the person feels that something is going wrong and is not in a position to get it registered for so and so reason, and he creates some sort of a codicil. Codicil is nothing but an amendment to a will kind of a thing, wherein he suggests that, okay, there are changes in the will and this so and so thing has to be further rectified. That also can be considered. If at all contested, then the court will take a look into it, if it is forgery is there, or any undue influence is there. For any sort of a concerns, for example, in registered will also and unregistered will also, the person should be hale, healthy, and of a sound mind when he creates a will. Because he should be healthy enough, first of all, and mindful that whatever he's drafting is in 100% line what is being further shared. There should be no ambiguity with his health issues also. For example, if he's an Alzheimer patient, then there is a concern over there. He should not be taken in front. Technically, for example, there are a lot of people we come across that the sub-registrar office will go just put the Aadhaar card, PAN card and take his photograph. He'll just put a thumb impression. No. If technically prove that he was not hale and healthy at that point of time, the entire will get cancelled also. So the court takes the entire authority to see how to further take it up. Then the partition suits and property dispute starts over there. So, over to Arun. Thank you.
Yes, sir. Thank you, sir, for your practical insights. These are very helpful. So moving ahead, so sir has spoken already on the probate process. So questions generally come up: is probate required, and is it applicable everywhere? We understand it is not applicable in every state. It is applicable only in princely states, that is Mumbai, Chennai, and Kolkata. And generally, probate is necessary in these states if there is a immovable property involved. So,
and if there is dispute also is there, then probate is better to take it up.
Probate is understand, sir. Got it. So moving ahead, can a bigger share be given to a particular child? This is a common question children have and parents have also. So, is there some insights on this?
So basically, when it is a self-acquired property, I'm not touching base anything about ancestral inherited property. If it is in self-acquired property, any parent can decide on, for example, as today case also example I shared, if the single child, these are two kids, and only one child is looking after the parents, other child is least bothered for whatever it is. So they have every right to suggest that 75% of the entire property go to my son only, and 25% go to the other son who. That's where it comes like we suggest that conditional thing, like because he has taken care completely of me until unless whoever, it's like a joint account, sir, either a survivor basis, and the survivor will get the entire share, and rather afterwards my elder son who has looked after us very well, he will get the 75% of share, remaining 25%, just because there should be no ambiguity, he or she will share it across to the second child. So if self-acquired property, a parent has 100% right to think and create a will in as per their own vision. It can be pertaining to finances also, or the property also, movable, immovable property, whatever it can.
So this is always a contentious issue, I think. And correct me if I'm wrong. So if there is a disproportionate share done amongst the children, the parent also should ensure that there is a justification attached to it as to why the disproportionate share is being done. Otherwise, it can be generally challenged and it unnecessarily goes to the court.
100% agree. So as for example, today's case only which I came across was the entire house loan was taken by the last son. He did the entire stuff. The construction was done. The 100% proof was there to show on record that he has put his hard and hard-earned money for that entire property. Just because father had purchased the site doesn't mean that 100% will go to the father, other kids also. So it was substantiated. The value of the site was more or less than what he has invested in construction the entire building. And the 20-year span, which he looked after his parents. For example, it's a technical example I'm giving, when the entire looking after the parents, looking after their day-to-day needs, their medical needs, everything has been looking after by one particular son, and others have not even bothered for it. Then the court rests its order also that let everything goes to the as per the will or as per the what do you say? Sorry, emotional aspect of the parent, that let 75% or 100% go to the son itself, like the last son, that way to say.
Understood, sir. Understood. So moving ahead. Yes, we discussed about self-acquired or inherited and not ancestral. Yeah.
Correct.
So this is another aspect that we have come across in the recent past. Even Supreme Court has mentioned this in one of their judgments, saying the parents, while gifting or even while creating will, they should ensure that conditions are attached. For example, if a parent male member, that is father, is writing a will, he should ensure that his spouse, that his wife, is taken care of. And if wife is writing a will, she has to mention that father, that is husband, is taken care of. So this way, their living and the standard of living, etc., are taken care during their old age time and not left with hanging in between. So this we all understand, and we should also ensure that these are practiced. Whenever we come across that somebody is writing a will, we should ensure that they also cover these aspects also. Okay, moving ahead, settlement deed and release deed. Sir has beautifully explained what is settlement deed and what is release deed. Release deed is where they own the asset and then they release it. Settlement deed is when they do not own, but still they ensure they promise that they will not have any right or claim over the assets into future also. That is how settlement deeds and release deeds work. And generally, settlement deeds or release deeds are permanent, irrevocable, because it is executed between all the parties, and that cannot be revoked. And it is registered. It has to be preferably registered again. And it is used as a mechanism to settle and avoid any kind of disputes amongst the family members. And it is a legally binding document. Even as a buyer, when I'm looking at legal due diligence of the properties, if there are any settlement deeds or release deeds, we ensure that legally it is reviewed by an expert and then an opinion is sought on these aspects, because it has a bearing on the ownership of the property. Moving ahead. So yes, this is one of the paper clipping where I was talking about that conditions, explicit conditions, and it has to be clearly mentioned to ensure that parents are taken care post the gift or the settlement deeds are undertaken. Revocation and cancellation of will. Will, as we understand, it's a document written by the testator, and he or she is allowed to write n number of wills throughout the lifetime, and the last one supersedes all the previous wills, unless and until it is specifically for particular asset or so. So that is one aspect. And execution of subsequent will generally revokes the previous will, or even when there is a declaration by the testator saying that he intends to revoke the previous will, that is how the will gets revoked. And destroying or tearing or burning or by any other means destroying the written will also ensures cancellation of the will. But here I have a question to sir. If it is a registered will and if we destroy or tear or burn, there is still a record with the sub-registrar. So should we still go and register a declaration of revocation, or how does it work?
No, we have to properly go and do the cancellation of the will. Because if it is registered will, we have to follow the entire process. because it's already in the record.
Understood.
Just by destroying or tearing it off, it will not work out. We have to do the entire process and get it cancelled there in the records.
Yes. The last point, sir, is also tricky. We wanted to understand from you. When a person writes a will, he's still not married, and post-marriage, will the old will get revoked?
Automatically will not get revoked. Again, he has to make amendments. Codicil has to be created, or he has to create a fresh will. It will not get automatic because it is not married that time. After he is married, he has to create all sorts of benefits for the spouse in that case. By
Understand.
default, nothing will happen
Got it.
automatically. They have to create a record for it. And if it is a
Got
registered
it.
thing, then you have to get it properly through registration only.
Got it. Understood, sir. Moving ahead. So common questions that we come across will I'll skip now because I am sure the questions also from the participants will be in line with this. I'll skip for now. And so how do we take this forward? Now that we have understood all about will, and if let's say I want to do a will now, what do we do? We have to identify assets, all our assets, and ensure how the ownership, identify how the ownership of those assets have been obtained. Is it through a settlement or through inheritance or self-acquired? Check if all our bank accounts and investments have a nominee, and ensure we do not have single account. We generally suggest it should be jointly held or at least a nominees are mentioned. And then write a will, use a legal expert to write a will and ensure there are witnesses, ensure there are executors identified, taken their prior approval, and then also ensure the passwords and for all the online access as well as the lockers are documented in one or the other place and documented in one place. And registration of will is recommendatory and not compulsory. And ensure the will is updated at a periodic, reasonable intervals because every year we keep generating and creating additional wealth. So hence the will also has to be updated at reasonable intervals. So this is the common process of creating a will. Of course, based on the case and the nitty-gritties, there may be added processes that a legal expert would be able to advise on. So participant, there will be a poll here launched by my colleague. Please participate. And moving ahead, we'll briefly touch upon the aspects of private trust. And for this, I'll call upon my colleague Maithili. She will take it over from here. Maithili, over to you.
Thank you so much, Arun. And good evening, all of you. I will take forward the aspect of private trust. I think we've had a reasonable idea and a very compelling reason as well as to why we need to have a will. Though it is something like an ostrich syndrome we always have and we don't want to face it, it's an absolute important. And I always personally vouch that where we have women, we have different type of roles that we play across our life. So there, the importance of women to actually have a will is much, much important because of the concept of a legal heir where the law is always skewed towards your family side before it actually takes care of you. So it's very important to take the reins and decide for yourself as to whom your assets actually go to. That is one important thing that we wanted to emphasize there. Going forward, another alternative aspect of estate planning that we often come across is a private trust. Now, private trust, if I have to simply put, it is another tool for estate planning.
Sorry, we have lost. We are not able to hear.
Arun, I think Maithili is gone offline. Can you continue that till she
Yes,
comes
yes.
back?
Yes, Vivek. So as Maithili was mentioning, private trust is an alternate for a will here. And generally, the process of creating a trust also is important to, as part of the process, it is also important to understand whether
Yeah.
Yeah, go ahead, Maithili.
Yeah.
You're back.
Yeah, sorry. This is what happens when you have a family where your kids are at home and they decide to stream. Very apologies for that. Okay. Why the concept of private trust and will, the way it works is will takes into effect post the lifetime of a person. The beauty of a private trust is you can see it in operation during your lifetime, ensure that it is working, the mechanics are in place, and then you can actually test the waters even when you're alive and see how it happens if you are to be out of the equation. So that is the beauty of a private trust. So typically, a private trust involves an aspect where you pool your assets, similar to will. The whole concept of creating visibility of all your assets, you can pool it into a separate vehicle, which will be a trust. And the creation of trust is for the benefit of the beneficiaries. So there is always the concept of three-way call. Arun, if you can go forward. So one other aspect before I come on to the aspects of with regard to who are the parties to a private trust. The beauty of a private trust is it's extremely it can be a custom made document which you can dictate how the entire mechanics has to be, and you can constantly update it with your requirements as to who your beneficiaries are, etc. And generally, we state that once it has gone into the private trust, the automatically the succession laws doesn't immediately take place. So, and if you, it is beautiful in case where there are concept of business assets where you want to delink ownership and then operations separately, where you can create all your set of beneficiaries under a single vehicle, and you can have somebody else to manage the whole show without having the ownership and managing as blended into one single mechanism. So this is one of the beauty aspects of why a trust is better than a will. Mr. Santosh, one question that we generally have is with regard to the probate process. Now, the general idea is that a probate process is mandatory in case if it is through a will. Whereas if the assets are through a private trust, then probate process doesn't kick in post the life of the settler. Is that true? What we hear, or is there any another lining on the whole thing to understand it further?
To be technically or practically, unless until there is a dispute for any sort of a thing, no one can. It's not mandatory to reach the court actually. If there's a dispute in a will or in a trust also, then only we can reach out. Same example of Sanjay Kapoor. Everything was crystal clear unless until the mother found that some sort of a issue over there, she started knocking the doors of the court. So when the dispute arises, by default, we can reach out to the court.
All right. Going forward, why the common compulsive need as to why you need a private trust? There are a lot of compelling reasons as to why we prescribe for a private trust. One of the main cases that we actually, as a thumb rule, we provide is that where there is a lot of business liabilities associated with a business being handled by the family, etc., it gives an easy mechanism for us to provide a concept of a ring fencing so that the family assets are preserved and there is a sort of a it doesn't feed into your personal assets, all your business liabilities. So that is one. Second is perpetual existence. It's almost like works like a Magna Carta where you define how the entire your proceeds or your wealth has to devolve on subsequent beneficiaries. It is almost like managing your life beyond the grave. Will also does it to a great extent, but in this case, you have an umpire or referee sitting in the form of a trustee who also ensures that the mechanics are implemented. We have seen in the case of most of the trusts like a Tata Trust and any of the big families that you've seen, we have seen a case of a private trust and where a trustee actually ensures the management of the assets. So it goes on from generation to generation. Now, another compelling reason where people have is a manner of easing the administration of the assets. Private trust provides you a definite pool where you can create a pool under one entity so that there is ease of administration. In the current case, we see that people don't want to take up the management of the assets, and sometimes it's just too overwhelming. So, a trust provides a mechanism whereby the beneficiaries are ensured that they get the benefit out of the funds, but the entire management can be shifted to a trustee who will actually manage the assets on behalf of the beneficiaries. So it provides a sort of a delinking as to one who wants to enjoy the benefits and the one who has to take the responsibility of managing the assets. So that also can be delinked in a private trust. One specific, we always have this whole concept of inheritance tax. We have heard it in multiple cases. After estate duty, we have seen it in the form of wealth tax. We don't know when this monster will surface, but whenever it is going to, private trust, we believe, would actually provide a mechanism whereby it will help you overtide the erstwhile estate duty implication that we had, because it's a seamless movement of assets through another vehicle which is already in existence, and it doesn't come through your inheritance angle, and the beneficiaries are already laid out. Now, one more areas in the recent times that we have actually seen a compelling case for private trust is in the case if you have a differently abled child or somebody who needs to be taken care of. In those cases, we believe that a private trust provides a very clear mandate in terms of managing the assets for the child and how it has to be taking going forward, because there is also the question of who will take care of the child and whether the child can actually enter into contracts for any sort of execution. Private trust gives a much better sort of a relief where the parents can always ensure that the child benefits are always taken care, and the mechanism as how it needs to be can be clearly laid out, the care requirements can be laid out, and how the assets will move post the life of the child also can be clearly spelled out. So this also provides a certain sort of a clarity with regard to the way forward. Now, Mr. Santosh, one thing we have actually advised in most cases is with regard to differently able children or people with Alzheimer's and those sort of scenario where um, if you don't have a will and you want to ensure there is a working operation over the when the person is alive, there is always some mechanics which is clearly laid out in a document. Is this sort of an approach that you would strongly recommend, or is what happens if you don't have a natural guardian and who doesn't take care? Because the concept of public care is very it's still not perfectly formed out in India.
Yeah, there's some practical tips I would suggest for a parent who has a differently able child over here. Draft a clear, irrevocable trust deed, basically, I mean, this private trust deed, basically. Appoint at least 2 trustees. So it can be someone, if something goes wrong, also preferably it can be the other person. And preferably, you would suggest in that 2 trustees, one should be a professional, for example, an auditor of that entire third accountant who is looking up, or any institute also, because one can be relative, another person is there who can overshadow and see as a neutral body also, and he can check whether things are streamlined and properly worked upon as per the parents' wish. Then define child, it should be very clear that what are the requirement of the child explicitly in the deed. So there should be no ambiguity in that, and the money or whatever has been usage is done is clearly been used for the so and so performance of the day-to-day needs of the child also. Assign insurance policies for both movable and immovable properties in the trust. And as preferably when the professional is there as a neutral person, he will take care of all those assets, which other normal other sibling or any other relative would not be able to understand all those things. And provide for a successor trusteeship for long-term continuity. So that also helps in the long term. So these are certain practical tips which each parent has to keep in mind when such kind of trust are being built. Hope that clears.
Thank you so
Thank
much,
you.
sir. This is very, very useful. So this is actually a very compelling reason for any cases where we have seen or any of your friends or relatives who have actually the necessity. This is a beautiful vehicle that we realize will ensure the protection of their children going forward in the future. So moving forward, when we have to try to understand how a private trust mechanics work, we have to understand three specific roles which are integral to a private trust. One is the settler, one is a trustee, and other the beneficiary. A settler is similar to what we call in the will scenario as a testator. The settler is the person who intends to move his assets, and he wants to ensure that his assets are being taken care for the benefit of certain beneficiaries. Now, the beneficiaries are the people who are named as part in the trustee, and they are identified by the settler, and the assets are held for their benefit, but they don't actually own the assets. That's the beauty of a trustee, how it works. Now, for managing and owning the assets and ensuring the mechanics of what the intent of the settler is done, you have the trustees. Now, the trustees work like a power center, and they, with as they say, with a lot of power comes a lot of responsibility. The fact that they are able to manage the assets also puts them in a spot of responsibility where they need to ensure that whatever that they do is as per the intent of what the settler has created, and it is actually enduring for the benefit of the beneficiaries. So it is a lot of responsibility that particular post, and it is important to name people who can actually take up this responsibility before you provide that responsibility to these trustees. If it is not yourself who's going to do it, you need to take their consent, and they should be clear as what is the kind of role that they are going to take up as part of the trust. So these are the main three integral part of the trust deed. All these three have their roles, which are also defined in the Trust Act. Unfortunately, we have inherited a lot of things from the English Act because they ruled over us. Good or bad, it may be. The concept of trust is something which we have derived from the English law, and it is there from 1882, and it is still present. Surprising, nobody has thought about revamping that law, irrespective of so many changes that we are thinking of doing right now. But anyway, nevertheless, it's a mechanism which has been widely used in the current state, because people have understood that there can be a scenario where you can provide your assets and your children can enjoy it without actually being having full access to the asset. So this is where the trust generally plays a very great role. Now, going forward, as to define what are the different roles in the trust. One important thing that we do, the entire mechanics for this, because you don't have a very strong law to determine how it works, the trust deed works like an entire Bible for the whole operation. It has to specify everything and anything, and to what your intent is with regard to the asset going forward is completely spelled out in the trust deed. The more detail it is, better, but sometimes too much of information or something, it should not result. Be always careful of the fact that the intent is for your children to have the asset and not have access to the asset. So it should not be too choking that they don't enjoy the benefits of the asset. Be mindful of that, but at the same time, if there are certain not negotiables for you, that can be instilled as part of the trustee, and the trustee can provide you the mechanics as to how it has to be operated. The entire thing is spelled out for the trustee, and the trustee is the one who takes responsibility. That's why when you register a trust deed, you need to have the settler as well as the trustee who will have to sign it at the time of registration of a trust deed. Now, what all can it provide? It can provide the roles, responsibilities, powers. If there is somebody whom they need to consult, you can also provide those kind of mechanics inside your trust deed. Now, apart from the three main core responsible people that as part of a trust, we have other sundry things that we can have in order to make your administration and mechanism better. We sometimes have people who come in the role of an observer, or sometimes who takes up the role of an administrator if there is no trustee. So the administrator basically works like a backup option if nobody is there, what you need to do to wind up the trust. An observer can be a person who doesn't want to actually take up the full-fledged role of a trustee, but still the settler trusts that person, and he works like a person who can provide a wise counsel to the trustee in case they have any issue, or if there is certain sort of a dispute, they want to have a counsel at somewhere. The observer can be a person who actually sees whether the trustee is doing his job, and also sort of nudge the trustees, or ensuring that if there is any rift between the trustees and beneficiaries, it is sorted out. So they come in as to a wise counsel sort of a role. These are sort of roles which can be provided as part of the trustee. It doesn't have implications from the legal. The law doesn't provide them any specific powers. If there is something that has to be provided, it is through the trustee that they actually take up these sort of responsibilities. Now, going forward as to what is the roles of the different parties, we have to have a settler in order to create a trust. That is where the main intent is set out. And the settler generally appoints and identifies a trustee, and you create a specific trustee where you say who are the beneficiaries, and that gets clearly lined out. Now you can have, there is no sort of a cap on the number of trust you can have. You can have even multiple trusts. The trust can move with the kind of asset, or you can also move with the kind of intent that you need to create for each trust. Or it can be even beneficiary specifics. Like for you example, you have two children and you want to sort of create a mechanics for both the children. Instead of creating too much complication within one single trust, you can have clearly identified mechanics which can be put through in two separate trust deeds, and each child you can have it in a separate trust deed. So this is something that it's basically how much you can actually manage. That defines what is the additional responsibility you want to take up. Now, the trustee owns and manages the asset for the beneficiaries. Now, wherever the bank account, the operational, whether opening of a demat, closing, any transaction that needs to be undertaken for the trust assets, these will have to be done by the trustees. Now, you can have one trustee or two or three trustee. It is your call out. How do you want to have the decision making metrics to be put out? But there is one risk that you always need to keep in mind. One of the important criterion for a trust to exist is the presence of a trustee and presence of a beneficiary, and you should have some asset for to be taken care of. If you have one trustee and there is a demise of the trustee, if there is no mechanism or the beneficiary is not appointing, the trust can go into a wind up. So there is a trigger for winding up that can happen. So in order to avoid this, we generally recommend that always have more than one trustee, so that there is more clarity, and there is always continuity for the trust assets. Now, post all these identification, the important thing is to have a trust deed and execute it. Now, execution of a trust deed is also very vital, and you need to go and get it registered with the sub-registrar. So these are the general roles and what are the steps involved in a trust process creation. Now we have, just to give a brief as to what are the different types of trust we have a concept of revocable and irrevocable trust. Now, if I have to briefly explain what a revocable and irrevocable is, revocable is basically it's like having the child on a leash. You put the assets, you have created the content, but you still want to ensure that you can pull it back at any point of time. That is a revocable trust. Now, irrevocable trust is letting the child free. You take off the leash and you put everything into it and you say that the trust takes care of itself. So that's what an irrevocable trust works. Now, a revocable trust, the legal, though it is like testing waters before you actually do the job. So you can have a revocable trust in place, ensure it is set up, and over a period, once you have comfort of the particular operations of the trust, or when you are deciding to let go, it could be even if your time. Post that, you can make that particular trust as irrevocable, and automatically the trust becomes irrevocable trust. So this is sort of a mechanics, just like how trust works. The concept of revocability can also be built into the trust deed as to what would be the trigger point for an irrevocable trust, or for a revocable trust to get into an irrevocable trust. There is also the concept of taxation, which is uh, tax is part of our life. We have to reconcile to the fact that it always stays with us. So if it is an irrevocable trust, you always assess the tax as part of the settler itself. You take it back, pull it and add it to their income and assess it. If it is an irrevocable trust, then the trust determines how the taxation happens. So we come to the next concept of what is called as a determinate and an indeterminate trust. Determinate, indeterminate is very simple. Determinate, if you are actually able to identify who the beneficiaries are, how much they are going to get each of them, then it becomes very clear. You've identified their how much each their interest is. Whereas an indeterminate trust is you're still unclear. You're clear of the fact that you want to have a trust and the assets pooled in one place, but you're still unclear how much each person gets. You can decide, you can give the right to a trustee to decide how much each of the beneficiary gets. this can be even a complicated mechanism, or it can be very simple at the discretion of the trustee. So you can define the mechanics as to how the share of the beneficiaries can be determined. So this is the concept of a determinate and an indeterminate trust. So Mr. Santosh, one common question that we have is that whenever we have when you have a concept of an irrevocable trust which gets into effect post the lifetime of the trustee, of the settler, the question arises that what are the trigger points for you to go revisit the sub-register? Is it when there is a change in beneficiary, or whether normally we have something like a waterfall mechanism identified for the trustee or a beneficiary? Does any change in the name or the role of who is the beneficiary or a trustee, does it require us to go back and register the trustee once again?
Yeah, if anything, basically any document which is registered, and if there is any sort of an amendment, which is major amendment been created in the entire deed, it's better to go and get it an amendment registered. Amendment deed it is called. So you can go and get it registered, because further it should not create any sort of issue that unregistered document, anything will have a question. It will be disputed, it can be contested also, that was influenced or rather some sort of a forgery would be done. So better to get it register the amendment to that extent.
So if I want to identify subsequent trustees, it can be through a normal resolution that has been made by the trust board of trust itself, right? You
Correct,
don't need to have
correct.
a registration for that.
Not for that purpose, not required. Yeah.
So for example, if I have said that after me, my entire share will devolve on my spouse. So at that point of time, the initial what I would have capsulated is mine is 50% and my spouse is 50%. Now the beneficiary is going to become 100%, but it is laid out in the trust deed. Would it have a trigger point for registration there?
See, it depends again on the value also. If it is going into crores of rupees or something, a lot of benefit is going on, better to be on a safer side, create a document, get it registered. That will be more helpful actually.
And that can have work like an amendment or a codicil to the
Yes.
main document itself.
Yes.
Fair enough. So moving on, the concept of waterfall mechanism, if so why should the waterfall mechanism be provided only under the law? We also can take the law in our hands and create it in a trustee. That's the whole intent of a waterfall mechanism. So what happens is, in a waterfall mechanism, you can define who your first level beneficiaries are, who your second level beneficiaries are, and how it has to devolve post the each beneficiary level. So this is what makes a trust more or less a perpetual trust. You can have the concept only through this concept of a waterfall mechanism, where you can define what will be the first level beneficiaries and what is the next level beneficiaries. And the trustee will have to ensure that the beneficiaries are made aware, and it devolves in the certain specific manner. Now, common things that we see as part of the mechanics is that why people take up trust. One of the other reasons is because of a lot of marital discords that come up. They are very clear that anything that belongs to them, they want to ensure that it goes through their lineal ascendants and descendants. So to exclude the spouses out of the equation, to ensure that the assets are purely for their children, their generation, their descendants, the whole concept of excluding people from the trust can be enabled. You can't do it under a succession law because your hands are tied because of what the law says. Whereas the whole beauty of this is you can create that sort of an exclusion mechanics under the private trust route, because the property is yours. You are doing it for a certain set of people. You can define when your beneficiaries will be entitled and when they will not be entitled. So you can also create an exclusion matrix there saying that if this happens, then my who a beneficiary name can be excluded from the benefit as well. So these are something that can be built in as part of a trust deed. So it can be as simple as you want or as complicated you want it to be. That is completely up to you. Now, going forward, now, one of the reasons as to why trust, a compulsive need for people who are having business assets is something that we say is the concept of ring fencing liabilities. This is actually the whole thing that had come up probably few weeks back on in the newspapers that actually made me start wondering as to why we need a trust and why is it that I'm actually ensuring people have a trust, especially in cases where people have business houses, is one particular UK proceedings that came up to my mind for Anil Ambani. Now, the beauty of it is you are rich, but you're not rich. The whole concept unfolds in this manner where he says that, yes, everything is there. I come and there are all enterprises are there, but nothing is in my name. This is exactly one of the reasons, and probably a lot of reasons where even case of alimony proceedings can be tided over because of this. That is something Mr. Santosh should throw light on, because a lot of people actually create trust in order to avoid marital discounts and ensure that payment to spouses, ex-spouses doesn't happen. So if you can sort of throw light as to, is it really a genuine case for creating a trust?
It's a very tricky situation actually, and that's what I said. When in a family disputes, generally in family disputes, this is the major role for that matter. That's where, to some extent, again, I can take repeating the same example. I should not say Sanjay Kapoor's thing, wherein it is to some extent when the divorce took place between Karishma Kapoor and Sanjay Kapoor, at least it was defined to that level that what alimony would go to, if everything is crystal clear and defined properly, because alimony was fixed for Karishma Kapoor and for the kids. 10 crores or 10 crores, I believe it's the right amount. I don't know. It's just giving an example. It's fixed and the fixed deposit was made. If it is everything is crystal clear, there is no dispute. Again, if it is not crystal clear and it's purposefully, intentionally done, then we can knock the doors of the court and get it rectified or get it cancelled or get it completely forfeited or whatever it can be to that extent. So it
One more
depends
thing,
because, yeah.
One more question,
So,
actually, which very commonly we see that we have had 2-3 inquiries where people say that, okay, I have suddenly one cases that is going on in my name. Can I transfer the assets to the trust and ensure that it is ring fenced? So that is something if you can touch upon as well. That is one common query that we have as well.
For that matter, if it is a civil dispute, if there is no injunction, you can do it. But if it's a criminal case going on, you can't do it. Because in 2006, I still remember there was one well-known famous builder in Mumbai who was arrested for doing some sort of financial fraud. And during that time, he had transferred certain shares from his account to his wife's account, wherein we had literally, as a bank, we had to restrict them, saying that when a person is in jail, he can't do anything pertaining to his property. So in civil cases, unless until there is an injunction or stay, it's okay to go ahead with it. But in criminal cases, complete no.
So if they actually transfer assume that it's a civil proceeding and there is a likely liability that can come out and the proceedings is still on. I have a certain value of an asset which I think is formidable and I want to transfer it today. Does the court have the right to go beyond the wheel of the trust and say that you made this transfer in order to avoid this payment? So the whole transfer is actually void ab initio.
No, for that matter, we have to bring it to the notice of the court. Unless until the things have been presented clearly, the facts have been not cleared properly to the court also can't take an action. That's the reason when we approach the court, we ourselves have to go with the clean hands, and the other side also, if he's contesting it, he has to give it with the proofs that there is some sort of transfer or some sort of a hanky-panky thing done by the other side party. In that case, the court can intervene and directly give an issue also without, they can directly go ahead and suggest that injunction is there or stay is there or any sort of instruction to that extent.
Okay.
They can withdraw, as rightly suggested, sorry to interrupt, void ab initio. The court has a right to get it done because it has an inherent power for that matter.
So it actually has an inherent. So it actually can negate the whole transfer and say, let's all go back to where we were.
Yes.
Perfect. So one other common question that comes up is with regard to what is the asset that you can put in to the trust. We generally opine that it has to be your self-earned or you inherited assets. When I say inherited, ensure that all release deeds or any settlement that has been done, it is all in place and you have absolute title over the asset. You cannot transfer onto a trust what you cannot transfer to you, where you can't give a full title to the beneficiaries, you can't transfer it to the trust. So even if you make such sort of a transfer, the fact is that if it is an ancestral property, it is not something that you decide and you put it forward unless you have all the release deeds in place.
Correct. Very true. Very true. One more thing I just want to add to this. Nowadays, there's a culture, a lot of people coming up with numerology and change of name. I've come across a recent case also, just wanted to share a thought over it. How it happens is 20 years back, one person had some name, Ramesh KCP or something. I'm just giving a fake name. And later on, his numerologist suggested, no, Ramesh KCP is not correct. Go for Shanta Kumar. So earlier properties were named in Ramesh Kumar Sipit when Aadhaar card and PAN card was not mandatory that time. But recently, he changed his name because of the numerology thing and he purchased some few other additional properties. And now Aadhaar card and PAN card is there. This becomes a very tricky situation now. So that's where we have to go knock the doors of the court, stating that Ramesh Sippi and Shanta Kumar are the same person and the properties belong to the same person. Technically, there should be no ambiguity in any sort of a record over there. So keeping in mind nowadays the change of name concept also, we have to see that there is no ambiguity in all those issues also. That's where if you see in certain records, we suggest that Ramesh alias Shantakumar alias Krishna Kumar alias, all as one and the same person. So that's how it comes in the registered deed also. Sorry, it just strikes my mind. That's why I just shared the example here. That's the thing.
Sure, sir. So it's surprising actually how that happens because now with the Aadhaar PAN linking, they don't even allow you to do a linking unless there is absolutely clarity with regard to A and B.
Correct,
A and B being the same person.
Yeah.
Fair enough. Okay. So another aspect is with regard to registration of trust. Now, what trust can contain? It can have both the movable as well as immovable property. You need to have the trust deed registered and you need to have proper identity of the settlers and the trustee. You need to have a witness in place. Then whatever the property is being transferred or if any money has been settled in favor of the trust, we have to mention that and you need to go and get it registered with a sub-register. So common mechanism that we provide is that if you want to set a trust in place, go set it up in place with a nominal amount and ensure everything is in place. You have a PAN, you have a bank account, everything is in place. And post that you make any transfers to the trust if required. That can be easily enabled. The critical part is having the bank account open and having a PAN in place and having the trust deed registered. So once that is there, then all the other automatically gets open. So this is one of the very brief on what is the registration process with regard to trust. So now we'll open it up for the Q&A.
So we have a poll, participants request you to participate and then we'll move on to the Q&A session. So before moving on to the Q&A session, I would thank once again, I would like to thank Mr. Santosh Murthy for his participation and thought-provoking inputs and the clarification that you have provided, sir. Thanks for making time. And we request you to, help us in addressing the questions also raised by the participants. So, So the first question, so I'll read out the questions and then we'll open the floor for further questions. So the first question is by Mr. Sandeep. For real estate properties, if we have made a will documenting the beneficiary, is that all that is needed or does anything more needs to be done to ensure smooth transmission?
For this question, I would clarify more in detail, saying that when you create a will, put every detail of the property what you have. Don't just create only will particularly for a real estate property, just like immovable property. Create everything what you have, the assets, financial assets, your jewelry, anything immovable also. It's better to be clear because just by putting the house, one house go to the one son, other house go to other son. What about the rest of the immovable properties? You may have crores of jewelry also with you. So that also creates a dispute in today's life. So better to be crystal clear in all aspects of financial, which can be movable and immovable. Sorry. Am I clear?
Yes, sir. Got it. Thank you, sir. So, Mr. Sumant, next question he is asking, can you please explain business assets in estate planning? I think this part we will touch upon in our next webinar in detail. We'll cover these aspects. And Mr. Vinay is asking, can a beneficiary be the executor also? So this is, I
No.
think he's asking from a will perspective.
No. A beneficiary can't be an executor. They have to be
Understood.
separate people over here. Yeah.
Got it. His further question is, can you throw some light on required documents that are to be taken to the sub-registrar at the time of registration of the will? I think the ID proofs and address proofs and a document, a will document, and the ID and address proof for both testator and executor. Is executor also necessary to be present, sir, when registering a will?
Generally not, but if to some extent, if they take a photo and all those kind of things. Nowadays, they make full proof, so that also helps a lot, because when it reaches to anyone reaches to the court, uh, technically, why photo is taken is to see that the same person, the same Aadhaar card number is there. So it's better to be
Understand.
present. Yeah.
And witness certainly has to be present there.
Yes.
Got it. The next question, Mr. Sumant, is which are the acts that I can refer to understand better about? So this we have covered in the slide. There are 3 succession acts prevalent in India. The next question is by Mr. Murli. Can a person draw a new will post the earlier registered will? Which one, the subsequent one is valid? So this also next question is by Mr. Sumant. If there is no will or private trust, we understand that succession happens according to the succession laws. But who decides which asset should go to which legal heir? This is a very nice question. How do we do this then?
Yeah, generally that's what we say. Whenever such kind of things, when nothing is there on record, it is basically if the dispute is not there within the family, there is no question of reaching out to the court. As a lawyer, as an advocate, people come to me. I suggest them very purely that you should not knock the doors of the court and the police station unless until it's really required. If things are getting settled amongst yourself, if there are 10 properties, then divide it across your release deed, share it amongst yourself. When you have a dispute only, then reach out to the court.
So
if
even
amicably
when
things you can sort it out, get it sorted out within yourself.
Understand. So even when people reach out to court also wants to have valuation of those assets and then divide amongst the legal heirs.
Correct. And
But
nowadays the
then,
court also have come up with the this mediation concept. When quarterly once they make them parties to settle also. If they get settled amongst themselves, well and good. The court also don't go into partition suits in that case.
Okay, got it. So the next question by Mr. Sumant is, can beneficiaries of a private trust transfer their interest in the trust to others? Maithili, you want to answer this?
So, as per the trust law, you can actually transfer the beneficial interest. But we have also seen some of the cases where the settler says that you cannot transfer the asset. So, Mr. Santosh, if you can actually help us there, if there is a legally, we actually have a mechanism where a beneficiary can actually transfer the asset. But the intent of the settler is to keep it within the family and ensure that the beneficiary don't do some extreme things where they can transfer. In that case, can we be restrictive in our trust deed?
Yeah,
And will the intent of the settler work?
Yeah, very rightly suggested, right question. Conditions can be imposed over there, that's for sure. That we can do it. Yeah.
Understand. So the next question is by Ms. Sujata. She's asking, please explain the difference between release and settlement deed. Does both require signature of all parties involved in case of an immovable property?
It's a minor China wall between settlement deed and a release deed. Release deed is completely like relinquishing the entire rights as I suggested. Settlement is negotiated, as I rightly said, there are 10 properties and there are 3 brothers. So they settle amongst themselves that 3 and 1 property is there, which who will take it across. So that's where the settlement deed also comes across. And for that matter, if they insist that no, my future generation will have an issue, release deed is completely relinquishing the rights. Settlement is towards that only extent. So if you see the weightage, release deed has more weightage than settlement deed. Because completely we forego the rights over there. That's what.
Got it, sir. So the next question, Mr. Kiran is asking, in case of joint bank accounts, that is bank accounts held jointly between two parties, what percentage of the bank balance can be considered in the will? How to avoid dispute between the joint holders? So I would think bringing a joint holder, generally it happens between parents and children or between spouses. That is how this is only from ease of operations perspective. Joint bank holders or account holders are brought in. But when it comes to the devolvement, how does court looks at it, or how do you advise your client, sir?
Sorry, I didn't get the question properly. What does it
When
mean?
there are joint bank accounts, how do you address it in case while writing or preparing a will?
The joint account is basically either of the survivor, correct? And the will
Right.
also, when it's drafted to that extent, and if they are disclosing among, if generally it so happens, joint account by default, both the parties know about it. So when both the parties know about, for example, husband, wife only, the will also can be created as either in the survivor. A single will also can be created. That after my demise, my spouse will be taken, considered the whole and sole rights of the property. So that way it can be handled.
Got
Similar
it, sir.
concept of banking transaction only.
Mhm. So the next question is, can a normal child who is a minor be named as one of the trustees of a private trust created for differently abled child? Can the settler himself be the trustee? So I would say a minor cannot be named as a trustee to start with. He should be a major, and settler himself can be a trustee. Yes, possible. Settler himself can be a trustee to start with. And as Maithili mentioned, there can be a waterfall mechanism where post his lifetime, he can identify subsequent trustees also. Next question is by Mr. Venkat. Is stamp duty applicable while transferring assets to private trust by a settler? So we observe the stamp duty, which is a state law, prescribes payment of stamp duty in line with conveyance of the properties in case of immobile property. Hence, we have observed that in case of immobile properties, recommendation is that the property be willed in favor of trust. And any mobile properties, financial assets can be easily moved without implications of the stamp duty. The next question is, if husband and wife have their own self-acquired properties, inherited assets, and ancestral properties, is it advisable to have separate private trusts? So again, I would say every case has to be identified and analyzed, and the purpose has to be defined very well to form a private trust. Many a times we have also observed there is a parent trust and child trust also. So this waterfall mechanism is also adopted like a holding company and subsidiaries. Similarly, the trusts are also created, and there is no bar on creating multiple trusts. I understand Nizam of Hyderabad had 51 trusts. Some of them were charitable trusts, but still he had 51 trusts. So that way we can have n number of trusts. However, the purpose has to be defined very well. Next question by Mr. Murli. If some of the trustees are NRIs, what are the tax implications? Maithili, you want to take this up?
So, the concept of taxation of trust comes, we have not delved in detail. The concept of taxation of trust comes from a beneficiary, whether it is a determinate or an indeterminate trust. Now, the trustee's role is as a representative of the trustee. A trust is what the role is. So, generally, if while clubbing, when you have to do, you directly either assess it in the hands of the trust or you assess it in the hands of the beneficiary. That is how the normal mechanics it happens. We generally say when we have the trust deed also say the trust is situated in India. So we, irrespective of who the trustee is, generally the trust mechanism for taxation happens as per the Indian rules. Now, if you have a non-resident, it is a dicey situation in the sense that if it is a sort of a trust where you have to assess it in the hands of a trustee because he is the person who's representing. the concept of where they're non-resident will actually work, but it is sort of an anomaly created by law itself because the trust is in respect of assets which are sitting out in India. So there the anomaly will work, but where we generally say that the trust tax residence of the NRA will actually come into play, but we generally can take a fair view that it is relating to assets in India, hence the applicable rules in India would apply to it.
Right. The next question is, are there any restrictions on parking ancestral property and inherited assets in a private trust? Sir, you want to address this?
See, that's what there should be a when you get an inherited property and ancestral property, if everything is crystal clear and documented, it has reached out to your hands, then you can get it done. If it is not, there is a dispute amongst there, or rather it's not been divided yet, there are still siblings fighting over that, you're not supposed to do it. If it's completely 100% in your hands, you can do, because Supreme Court also to some extent certain rules have said that once an ancestral property comes into your hand, you are the owner of the property. So that
Just
time you
to
can
add-
do it, but before that, you are not supposed to do anything on that case.
Just to further clarify what Santosh said is, as long as it is part of HUF, you
Correct.
do not have any right to put it in a trust or to will it as such. If
Correct.
it has by partition, it has come to you, it has become yours own asset now, then you can do that. Otherwise, HUF property cannot be put in a trust or in a will.
100% correct. Very true.
One more thing, Arun, to add to the previous one, operationally, what we generally do as part of this trust drafting is that we generally ensure that one of the trustee is mandatorily required to be a resident trustee. In order to tide off this kind of anomaly, we actually specify saying that one of the trustee has to be a resident trustee just to avoid this sort of an anomaly situation.
Got it. Thanks, Maithili. So the next point is, can trust pay tax in case of determinate trust instead of beneficiaries? So here, in case of determinate trust, though theoretically it is possible for the trust to pay taxes and report the income, there are no proper mechanism to report the income in the form of a tax return. We have tried this in the past, where in case of determinate trust, we wanted the trust to file the returns, but there is no place to report in right manner, because in case of determinate trust, the taxes have to be computed as if the beneficiaries are paying the taxes, and then that has to be pooled, and the liability also has to be arrived up accordingly and then reported. So that reporting mechanism is not available yet, and hence the beneficiaries has to report in case of a determinate trust. Yeah. So there are a few other questions. Before that, I see Mr. Manjunath has raised his hand. Mr. Manjunath, if you can unmute and then ask your question. Sir, you can you unmute? I think you have we have unlocked the unmute button. You can unmute, sir. Okay.
Okay.
Yes, sir.
So,
Yes, sir.
I want to get into the will mode after the discussion is over, after the first discussion itself. So, I have couple of doubts, like when I'm going to make a will in my daughter's name, uh, there are a couple of things which has happened in the last 4 years after the corona, like the all bank compulsorily they made it mandatory as the nomination in all the accounts and all the fixed deposits. When we are making the will, the nomination will play any important role, or it will be how we need to work on that, or how it has to be addressed. This is my question.
Got it, sir. Santosh, Santosh, sir, can you address this?
Sure. So, can you just clarify, you have only single daughter or any other kids also there, apart from your daughter whom you want to nominate?
Fortunately or unfortunately, only one daughter and only one wife.
Okay. So,
And
it's
we
a
are with the
good.
good terms and condition.
So it's great.
She
And
said
I
that.
think you're creating a will only for the purpose, either the survival basis till your wife or any of you are there, and later to your daughter. And your daughter being
No,
a
I
sorry.
wanted to make it both in the names. My question is actually in the bank. See, I work with HP for about 35 years. So we have a lot of accounts which is related to the company as well as the account where I made my wife as the nominee. Okay. So when we are making the will there, so nomination is separate, will is separate, right? Both you treat it as a totally a different entity. Am I
Correct.
right?
Correct, sir. Correct.
Okay,
Correct.
okay. In that case, how I should come out from the nominee? For example, there are maybe about some 1,000 shares in the HP which has come. I have put nomination as my wife. When
Correct.
I'm making these shares to my daughter in the will,
Hmm.
okay, as of now, or maybe I feel I should be proud to say they will be okay after my demise or after this one. They will not have any fight. However, to make it very simple with respect to the private asset and all these things, I wanted to make it very clear to the family also, so that this is the will, this is the nomination. Same thing with the bank account also.
Correct, sir. And nomination for that matter, it doesn't restrict a single person. Nomination can be 2, 3 people also for that matter. There is a concept there. And nomination is only a custodian. And you can clarify it in the will also that she is only a custody, the wife is only custody. If she requires, the daughter requires, you can just mention her also the 100% entire to take over the entire shares of HP also. Or rather, till they both are survive, 50-50 also can enjoy the benefits. So there is no concept or no, and first of all, if there is no dispute, sir, nothing to worry, because legally we suggest that whenever nomination is there, entire thing will get directly transferred to her account, and after her, it will go by default go to the daughter's account. That way it is.
Correct. That is true.
So,
That is
yes,
absolutely, there is no problem in the
just to
family history or anything as such. Just I wanted to make sure when the will and the nomination. See, for example, my father expired 12 years back. He had the nomination, but he was not having the will. When we went to the bank, he says the family tree, 4 brothers who are across the globe, we have to get it signed, attested, everything has to be done. Okay. Still is getting the pension because government has not cleared it. From last 12 years, he is getting the pension, he is getting the birthday notices, all these things. So when I want to put the full stop, okay,
just
for
so
this
then
kind of
let
a
me add in here.
nomination, yeah,
Manjana, so let me
what
just
could,
add in here
yeah,
as
yeah,
such. See, no, as you rightly understood, nomination and whom you mentioned as that asset to go in the will are two separate standings. Nomination has only a custodian to decide to operating it to see that suppose one person say for all your HP shares, you have put nominee as your wife. In your will, you say that HP shares has to go 50% to your wife, 50% to your daughter. Then it is your daughter's, because by nomination, your daughter is able to operate that account. And by that operation, she will put 50% into wife's account, 50% into her account. So that is the purpose of nomination as such. That is one. Second is also practically because people don't understand nomination properly. What we also suggest is when it says bank account, if you decided bank account A will go to your wife, bank account B will go to your daughter, that you mentioned in the will. Nomination also accordingly change it where it is possible. But sometimes it is not possible, it's okay. Nomination itself is a different one. Will supersede the nominations that you have given in the whatever you are given in whichever banks it is.
okay,
Yes,
thank you.
thanks to Mr. Santosh and Vivek clarifying this point. Sir, we will take it offline if necessary, further clarification is necessary. There are a few more questions I would want to address. So one question from Ms. Sujata is, what is the procedure for registration of immobile property in case of revocable trust? So first of all, registration of immobile property in favor of a trust, it will call for stamp duty. And if it is post lifetime through a will, there is nominal stamp duty applicable. However, during the lifetime, if the trust is irrevocable, we recommend not to transfer the immovable property in favor of the trust because it is revocable in nature. That means the settler can revoke it. That means once the revocation happens for whatever reasons, the asset has to move back to the settler. That being the case, again you will incur stamp duty. So there is no point in registering an immovable property in case of a revocable trust. Next question is it advisable for a CA to be an executor? If so, is there any prescribed limit or so? See, executor in case of a will is a choice made by the testator. That is the person who is writing the will. So first of all, he should be comfortable with the person whom he is going to appoint as executor, and executor's approval is also necessary. He or she can be a CA, company secretary, or any other professional, or a lawyer, or even a friend or a family member. There is no prescribed limit as well. And practically, how much power over the assets? Next question. This is practically how much power over the assets of a trust does a trustee have? I mean, it again depends on the drafting of the term and the clauses in the trust deed. It depends on how much the settler wants to provide, how much of powers the settler wants to provide to the trustee. So this has to be well thought, and all the permutation combinations into the future has to be thought about before arriving at list of powers or list of rights of the trustee. Many a times we have also observed there is initial trustees have certain powers or blanket powers, and subsequent trustees have limited powers also. And these powers are restricted even on the basis of class of assets. For example, if it is equity, the subsequent trustees should not invest in risk-based investments. They say it should not be utilized to invest in any kind of risk-based assets or invest in startups. These are the conditions that we have observed in the past. The next question is, if husband and wife are blessed with normal child and a differently able child, then should there be a private trust for differently able child and a will for normal, or can interest of both be served through the private trust? Yes, it can be served through the private trust. As Maithili mentioned and Mr. Santosh Murthy mentioned, the clarity has to be provided in the trust deed as to what assets are earmarked for whom, and who are how do they own and how do they have the beneficial interest in the assets. The clarity has to be mentioned. So there are a few more questions, but I think we have crossed the webinar session time. These queries or questions, we will take it up, and we will ensure we'll respond to these questions by an email, and further queries or clarifications we'll be happy to address on a one-on-one session. And we also want to mention here that on a non-committal basis, we are happy to have a 30 minutes session with any of the participants. It's a gift from us. Please utilize this gift from us and see how it can benefit your, on your questions or thought processes with respect to will as well as trusts. We will share the Calendly for booking the slots with us. And I would once again thank all the participants for taking out time from their daily normal routine and attending this. We hope this was very useful, and we hope to do more on these lines in future also. I would want to have any closing remarks from Mr. Santosh as well as Mr. Vivek.
Thanks for
Mr. Santosh.
Santosh, go ahead, Santosh.
Yeah, it's okay. No, it was a wonderful session altogether, and thanks Maithili, Arun, and Vivek giving me an opportunity and calling me as a guest It's an honor for me to be in this session, and wonderful entire participants also. Very valid questions been sought out. Anything required, we can reach out to Vivek, as rightly suggested. It's a gift 30-minute session. We're ready to give a special attention to all the queries what you have. I'm ready to resolve all your queries for that extent. And thank you, Vivek, once again for making me be part of this panel as such. Thank you very much.
Thanks everybody for this. This is part of our awareness session because we have been deeply seeing the emotions that runs and the troubles that has happened because of lack of estate planning. So that is why we have been doing this. So do reach out to us. Both Arun, Maitli, Santosh have done a great job in this. And also reason why we as Anveshan are involved as such. Most of the time people say that will estate planning is only advocates are involved, but why is Anveshan involved? What we understand is with Anveshan, we do the project management of the estate planning. We do have experts like Santosh and various other people with whom we work with. We take up the project management. We sit down with each one of the families, understand the requirements, and put it in a perspective based on the experiences that what we have, and then make use of the expertise of advocates and other consultants, and then give you a consolidated package. That's how Anveshan is involved in it. Uh, Thanks a lot for everybody for this. Thank you so much. Thanks, Maitli and Arun.
Thank you. Maithili, do we announce the next webinar?
Yeah, so as a second part series, what we wanted to do is take forward the test and estate planning in order to benefit the other entrepreneurs as well, where there are a lot of business assets, where there are corporate holdings, etc. Available. How can we also create a lot of less ambiguity, more clarity, and how we can structure the whole family arrangement. So we have seen there has been a change in guard in most of the enterprises where the next generation is taking over. They need more clarity and there is a lot of cap table cleanup that happens. So the second webinar, what we are hoping to achieve is ensure that there is a lot of when the clarity is there for the family and the mechanism as how it can be achieved with everybody on board is the main focus of us. So family constitution, family arrangement and business restructuring will be the next focus for the next webinar.
Thanks, Maithili. And we will be announcing the dates very soon and request to the participants to make use of that webinar as well. And we have many more webinars lined up into the future. We'll be intimating all of you. And thanks once again wholeheartedly for making time and attending and blessing us. Thank you. Thanks a lot.
Thank you all for a patient hearing. Thank you.
Thank you, everyone.